Are we? There we
But I'll say,
are.
how do you do? Hi, Rikki. How are you?
Good, Mosh. Nice to see you.
It's great.
Literally.
Yes. It's been a while. You're in the city right now?
I'm in the city, which is why you have the wood background. If I were at the beach, you would have the office background.
Got it. How are you doing? How is everything?
Everything is good. I cannot complain. And as my husband would say, and who would listen if they did? It's a very different. I don't think we're unique, or I don't think I'm unique. That the pandemic, made many of us very self-reflective
Hmm.
and deciding about what was most important in life. And it certainly changed the way each of us, I think, operates in the world. So I would have said no to almost anyone on the planet to do anything that I'm not contracted to do, except it's you. And I would, out of not only the fact that I like you, but I have an extraordinary amount of gratitude to you for all that you did for me when we were both at CBS. And I'm in a state from the pandemic of knowing that the most important thing in life is gratitude. And if someone has been good to you, you really, really need to be good to them.
Well, I'm so grateful for those kind words, and so grateful to you for. I mean, I would say the same from me to you, Rikki. That when we are producing hours and hours and days of television, that I always knew you to be somebody that no matter where you were in the world, you're like, Moshe, I can make 5 minutes available for you, and so I am so thankful for your you as a colleague, you as a friend, and of course for making time today as well, Rikki.
No, I thank you. I'm thrilled to do it. And I think the podcast format is a great format for you to be working on. It's also great for me, for my husband, who's been doing a lot of stuff because of his book that came out in June through podcasts, because you have the time to answer a question.
And it's revealing. My wife and I listen to podcasts all the time as we take road trips, especially, and it's remarkable that when you listen to some of the conversations of people, including people that you think or you've worked with or you spent many years with, and then you listen to a podcast, you're like, I had no idea. Like they just
Right,
revealed something new about themselves.
right.
So I'd like to welcome everybody to a conversation today with Rikki Klieman, a longtime colleague of mine and someone I consider a friend. Rikki is the CBS News legal analyst, a longtime attorney. We share a couple things in common, including we're both natives of Chicago. Though Northwestern rejected my undergraduate application, I should tell you, Rikki, you successfully were able to get into Northwestern, and then graduated eventually from BU Law School, served as an ADA in Massachusetts before starting your own practice, and then teaching law at both BU and Columbia University. Since 2015, you've been a legal analyst for CBS News, where we connected and worked very closely together on a number of the major legal stories of the last few years. I should also note you happen to be married to Bill Bratton, a former commissioner of police in New York, LA, and Boston. So you have a very comprehensive perspective on all things law enforcement, etc. Rikki, thanks for joining me today.
You're welcome. It's a pleasure to be with you. People have termed the relationship that I have with my husband, Bill Bratton, as either law and order. Obviously, I'm law, he's order. They've also termed us fire and ice. We get who's the fire. And they've termed us salt and pepper, and we get who's the pepper. So it's a very symbiotic relationship, but it also means that we have the ability, as we look at issues of both law and order, to have an interesting dialogue at home. And there have been so many cases in the year 2021 and 2020 that have affected policing as well as the law, and some very intriguing political issues that have come up as well with these cases.
Yeah, I'd love to dive into Rittenhouse, Arbery, a little bit Elizabeth Holmes, potentially Jussie Smollett. But I want to begin with the ongoing trial right now down in the Southern District of Manhattan, the Ghislaine Maxwell trial. where I've gotten the vast majority of questions. And so would love to get your perspective. We happen to be in a slight, I guess, break, you could call this, between the prosecution's presentation, the defense presentation that begins later this week. Some folks were surprised by the pace of the trial, that the prosecution was able to finish their case within 2 weeks when we thought it might take longer. So I'd love it at this juncture to get your perspective of where we are in this case and what you make of what you've seen so far.
I think that everyone was surprised that the prosecution took such a short time and rested so early. Originally, the trial was estimated to go into January. Certainly, no one expected the trial to go to a jury much before the middle of January, if not later. The prosecution made a decision. We do not know for a fact on what basis, but they made a decision to cut their case short. But that doesn't mean by cutting it short that it was in any way insufficient. I think that many of the people who will view and listen to this podcast will say, well, didn't we really expect to hear from those other unindicted co-conspirators? What about all of those people who worked for Jeffrey Epstein and allegedly with Ghislaine Maxwell? What happened to them? Why weren't they there? In addition to, why weren't there other alleged victims called? So if I can backtrack for a second to take a look at the case from the beginning, I've covered Jeffrey Epstein and therefore Ghislaine Maxwell since the end of 2018, when Julie Brown at the Miami Herald did this extraordinary amount of investigative reporting having to do with the exploits of Jeffrey Epstein and people he was close to traffic and sexually abuse young girls, that is, girls as young as 14. And what we're really talking about here is the trafficking, the enticement, the arranging for travel, the grooming of teenage girls from 14 until they reach the age of majority of 18. Jeffrey Epstein is said to have taken his own life in 2019. And suddenly, after leaving her out of all of this, suddenly all the focus left Jeffrey Epstein and the government's focus became totally on Ghislaine Maxwell. People have said, well, she's had passports from other countries, which are quite legal that she had. Why didn't she leave the country? No one knows. She certainly had the ability to do that. But ultimately, she became the defendant. As we know, she was arrested at dawn by the FBI in a very secluded home, and she did have armed security. And as a result of her not being accessible to the government during this period after Jeffrey Epstein was arrested until she was arrested, she has been held at an extraordinary amount of bail. And this is a bail, in essence, it's no bail. I mean, the defense has put together a package asking that she be released on $5 million bail, and she is, as they say in the law, being detained. So let's look at the case itself. Did the government decide to go after Ghislaine Maxwell because they didn't have Jeffrey Epstein? That's in essence a great part of the defense, that she's a scapegoat, that she's a substitute defendant, and that she should not be the one who is being prosecuted. However, if you look at it from the government's point of view, she was alleged to have been a partner from the very beginning with Jeffrey Epstein. And as a result of their very close business and personal relationship, she was really the madam in charge. She was the person, according to the government, who went out, sought out these young girls, knew, for lack of another term, what Jeffrey Epstein's type was, found these young girls and groomed them, enticed them, made them feel comfortable because she was the adult female in the room. And according to the government, she was therefore engaged as a principal in the trafficking of minors. So was this enough evidence for the government to put forth and say, we're done? We've proved our case and we don't need to do anything else. When I was prosecuting, I had that theory that you ought to put in the bare bones and just get your case without a chance to mess it up by a witness who could be cross-examined at a level that would hurt your whole case, and just put in what was solid. And that's my perception of what the government did here. They looked at what they had. They have 4 alleged victims. There's a little bit of question about one of them in terms of age, because she was an alleged victim in London, and she was 17 in London, and 17 was the age of majority in London. So you may only have 3 alleged victims that the jury finds were minors. Nonetheless, those 3 and the story of the 4th will certainly go to a long way for the government to prove Ghislaine Maxwell guilty beyond a reasonable doubt of the primary counts of enticement, of arranging travel, of conspiracy to do such things, and the big count of trafficking. And soon it will be the defense turn.
It's interesting, the bare minimum, because to the outside observer, the non folks without a legal background, the thought is, why not just overwhelm the jury with evidence, But what you're saying is, with every potential person you put on the stand, there's also the potential for a piece of the case or there's the potential for it to hurt your case as well.
Well, let's take the alleged unindicted co-conspirators, that there were other women who allegedly did the same exact thing that Ghislaine Maxwell did. That is, that they went out and they found other girls and they enticed them and groomed them and brought them to either New Mexico, Palm Beach, or New York City for Jeffrey Epstein and perhaps other men to sexually abuse. Well, can you imagine that cross-examination? And isn't it a question for the jury to say, well, why aren't these people sitting in the dock? Why is the only person who's sitting in the dock Ghislaine Maxwell? Did she do much more than these people did? Or are they ultimately just as guilty as she is and they get a pass? So
right. I mean, the question came up as regards to Virginia Giuffre, right? Virginia Giuffre, why is she not testifying?
Well, Virginia Giuffre is in another situation because Virginia Giuffre, now Virginia Roberts, she is what we might call a primary victim. She is someone who has gone very public, both in court in her lawsuit against Ghislaine Maxwell, which was settled. We do not know for how much money, but I can assume it was settled for a pretty penny, that she is someone who has appeared countless times on the airwaves and has been pretty consistent in recent times about her story, about what happened to her. And I'll tell you one thing. I think you have to be dead inside if you don't have empathy or sympathy for these youngsters when they were young. But it's hard to picture someone who is articulate as an adult as being a naive 14-year-old. And at this trial, the picture of Virginia Giuffre at the age of 14 made me gasp. I mean, she is a child. We've probably all seen, or most of us have seen, the picture of Virginia Giuffre with Prince Andrew that has been the subject of countless news stories, and whether or not she was, in essence, given to Prince Andrew in order for him to sexually abuse by Jeffrey Epstein and Ghislaine Maxwell. And we've seen that picture so many times that perhaps it deadens us to how young she looked. But when you see these particular headshots, just her head, her face, of when she was 14 years old, I mean, my reaction was, holy heaven, she was such a child. And then it changes your perspective, or it enhances your perspective, either way, as to how could someone do this to a child that young? And if you're a juror, and as a juror, you have or have had a 14-year-old daughter, or even perhaps a 14-year-old granddaughter, and you think about that child when you see this picture of Virginia Giuffre that the jury has seen, that has to really make you take a breath.
So with that said, then what do you make of the prosecution's putting on your prosecutor hat a decision not to have Giuffre, now Roberts, participate to testify in the trial?
She's highly vulnerable in cross-examination. We know that because she has been deposed in the Ghislaine Maxwell trial, and her story in former times is different in some aspects than it is in current times. You don't want the idea that the defense can argue that this is someone who, albeit was very young, but at the time that she met Ghislaine Maxwell and Jeffrey Epstein, but you don't want the defense, and these are good defense lawyers, to be able to destroy her on the witness stand and therefore cast doubt on the entire case. I think that she would have been a vulnerable witness in many ways because she has spoken so many times and because she has testified under oath in the past.
Well, that was one thing that did come up in the last couple of weeks, was that under cross-examination, several of these accusers were, the themes of the defense were, you've changed your story, and you're suddenly remembering Ghislaine being in places where during previous interviews, you only remember Jeffrey being there. Is that a effective tactic by the defense? And does it, as a corollary to that, does it show that has the prosecution effectively prepared their witnesses for cross-examination?
Well, we have to look at the defense lawyers, as I say, who are highly skilled. And the defense opening statement did one of the things that I have taught for decades when I've taught opening statements and closing arguments to lawyers, which is that it is very good to have an opening statement theme that you will carry through during your cross-examination and ultimately argue it in your closing. And it's helpful, and this is not being cute, this is laws of rhetoric. They use 3 M's. They talked about memory, they talked about manipulation, and they talked about money. So you had the theme of the 3 M's that the defense brought forth in its opening. And that is how they have cross-examined. Now, it's one thing that your memory, of course, changes over time. We're human beings. And you may remember something very clearly in the beginning, or you may remember it more clearly later on as you've had time to reflect. This is, we always do this, this test in law school where someone runs into a room and pretends to attack someone else in the room. And then you ask everyone, the students in the room, what they saw. And everybody saw something different. And then you ask them a few weeks later what they saw, and their memories are different. The difficulty here for the prosecution, and the prosecution can only go with what it's got. I mean, there are facts that are, as we call them, facts beyond change. So if a witness was interrogated in 2009 or in 2019 by the government, and the witness did not mention Ghislaine Maxwell, but now mentions Ghislaine Maxwell, that's fertile ground for the defense to say, oh, you mean you really have put Ghislaine in a situation or in a room, you have made her a literal child abuser, that is by her own actions, as well as creating a story and aura around her now because you want to please the government. Well, why do you want to please the government? Because there's a thought, according to the defense, that you got more money from the Epstein victim fund if your story was one that the government liked. Now, that doesn't mean that's the truth. It just means that that's the defense argument. Could it carry the day? Hard to say at this point in time, because no matter what the memories were of these 4 alleged victims, and even if it comes down to 3 minor victims, they are very consistent about their stories at the time of trial. So the jury has to decide, do they believe them now, despite the fact that they had inconsistencies in the past, including the fact that some of them did not put Galen in the room at the time that they say. So go ahead.
No, I guess one of the questions that, as you were speaking there, that I'd love to know from your perspective is who had an easier case to make here, the prosecution or the defense? And especially when you can compare this, if there's other comparable trials to this, basically, how difficult was the task the prosecution had over the course of the last couple of weeks, and how well did they do given the challenges they faced?
I think the prosecution case is a difficult case. I think the defense is far more difficult, but I do think that this is not a slam dunk for the prosecution, because you have witnesses that do have different memories from different times. But you also have to remember that their stories involve the time that they were children and the trauma that occurred, not only according to them, but according to experts, as to how a child is traumatized by going through this kind of activity, this kind of abuse. Now, when you look at the defense case is really, really hard. It's one thing to punch holes and try to create doubt in the government's case, but doesn't this jury desperately want to hear from Ghislaine Maxwell? Don't they really want her to take the stand? And I'll tell you, if I'm defending this case, I wouldn't put Ghislaine Maxwell on the stand for all the tea in China. I think that she has the potential to be an utter and complete disaster on the stand. And why do I say that? Because I've read her depositions from back in 2016, where she's been indicted for 2 counts of perjury on those depositions. They are not being tried at this time with these counts, but she is in total denial. And it's very difficult for anyone to comprehend the closeness of her relationship with Jeffrey Epstein and to think she was deaf, dumb, and blind.
What's very interesting is you bring that up. So the defense has a big decision to make as to whether to put her on the stand. We have seen a number of prominent cases in recent weeks. We saw Kyle Rittenhouse on the stand. We saw Jussie Smollett on the stand. We saw Elizabeth Holmes in the Theranos trial on the stand. And we saw the McMichaels, the son and father, on the stand in the Arbery murder trial. Obviously, some are pending. Rittenhouse was found not guilty. Smollett was found guilty. The McMichaels were found guilty. Talk to me about just what we've seen. And is it just that we see a lot of trials right now, or is there this new trend that we're going to risk it by putting the defendant on the stand, and how that plays into the defense strategy for Ghislaine?
Let me just correct one thing, because otherwise I don't want it to slip my mind. In the Arbery case, it was only the son who took.
Sorry, just the son who shot Arbery, correct.
Right. But putting all of these defendants together to look at defendants testifying, I mean, I tried cases actively on the prosecution side and the defense side for 20 years. Then I've been covering cases for longer than I would like to say, but certainly longer than I tried cases. And that means anchoring cases, that's gavel to gavel at Court TV for 15 years, and then becoming a legal analyst for different networks, including now my second tenure at CBS News. And you rarely, if ever, saw a defendant take the witness stand, except perhaps in a self-defense case. I was a proponent when I was a defense lawyer to never put a defendant on the witness stand. And on those few occasions which I did, it was always like a dagger to my heart, every single time they answered a question that I went, oh no, why did they do this? Why did they say this? It's one of those things that is just dramatically fraught with peril. Why is that? Because in any criminal case, the burden of proof is solely on the government to prove someone guilty beyond a reasonable doubt. The defense has no burden of proof, zero burden of proof. As soon as a defendant testifies, psychologically for the jury, that burden moves over from the prosecution, it goes across the courtroom, and somehow the defense develops this burden because the jury is very intent on deciding, do they believe the defendant or not? And if they don't believe the defendant, isn't that often the end of the case? So Smollett is the perfect example because we have a juror who has now spoken out who said, they just didn't believe him. I mean, they didn't believe his story. And so if you didn't believe his story when it was all about his story to the police, well, that was going to be the end of that case. On the other hand, let's look at Kyle Rittenhouse. I thought initially when Kyle Rittenhouse was called to the stand, my Rikki Klieman reaction initially was, oh, this is such a mistake. Because the Rittenhouse case, as it was prosecuted, was not a terribly strong case. There was a lot of video, there was a lot of photographs, there was a lot of information that had come in that helped the defense. So I said, why would they do this? Well, as it turned out, they were a lot smarter than I would have been because Kyle Rittenhouse's testimony, in great part, helped him get a complete acquittal. But it was, of course, as I say, a self-defense case often demands a defendant testifying. I've gone on record on CBS News and said that I thought Mr. McMichael's testimony was dreadful, and I thought that it was the end of the case because he testified, in essence, that they were chasing Ahmaud Arbery and that he posed no threat, absolutely no threat. And so they only chased him because he was running away and he was African-American. So what else did the government need to prove him guilty? Elizabeth Holmes, I think we will ultimately see, but I think that there's a supreme amount of arrogance in her taking the witness stand. And considering her aptitude in the world that created this myth of Theranos as a company, the idea that she's saying, oh, it really wasn't me. My boyfriend made me do this. I was under his influence. Well, I mean, you can't have it both ways, I say. And so I would not, if I were a juror, I just could not understand why I would believe that defense. So that brings us now, I think, to Maxwell. And I must say that we always have to remember the right to testify in your own defense, on your own behalf, to waive your Fifth Amendment privilege belongs 100% to that defendant. So if that defendant says, I want to testify, no matter what the lawyers may argue to that defendant in private, it's the defendant's right. It's the defendant's life. It's the defendant's liberty. And if Ghislaine Maxwell feels, as she felt when she took that deposition, when she could have claimed the Fifth Amendment then in 2016, but she didn't. If she wants to testify and feels that the world needs to hear her story, and she is the only one who can ultimately change the course of this prosecution, well, if you're her lawyer, you have to let her get on the stand.
So if we see her on the stand, it might not necessarily be because the lawyers think it's good strategy, but because Ghislaine has said, I would like to speak on my own behalf.
Correct.
As people have been kind of throwing some stones at the prosecution's presentation in the last couple of weeks, a couple of the questions I got was, given it's the government, could there be, and again, this case is full of a lot of theories from folks, but could it be that there are powerful people out there who don't want Ghislaine Maxwell to be behind bars. Ken, I guess a better way of phrasing this question is it possible that outside entities could have influence on the government as they present a case like this?
No, this is the Southern District of New York. The Southern District of New York is probably the most powerful, the most independent, the most ethical, and well thought of United States Attorney's Office in the country. We used to call it as lawyers, the most powerful law firm in the United States of America is the Southern District of New York U.S. Attorney's Office. I have ultimate faith in their integrity and their courage, and I firmly believe that they are going after Ghislaine Maxwell with everything they've got, and they made a decision not to call these other witnesses because they were vulnerable. One of the issues that people have wondered about, and I think we all do, is wouldn't the Southern District of New York make a deal with Ghislaine Maxwell if she could name other and more powerful abusers? The one that's obviously come up the most often, of course, is Prince Andrew, but there have been other people, celebrities, political people that have been thrown, whose names have been thrown out there for better and for worse. And wasn't there a way to make a deal? I have no information, and I don't know anyone who really does have reliable information that either the Southern District of New York really reached out to try to make a deal, or that Ghislaine Maxwell was ever interested in making a deal. And then we also have to face this reality. What if there isn't anyone that she could make a deal about? And if that's the case, meaning that she really didn't know what other people may have done with these young girls because she wasn't there 24/7 for all of these years. She was there most of the time, but not, or much of the time, but not all of the time. We don't know. But she's made her choice that she is staying in some of the most horrendous jail conditions. And she's not cooperating, or they don't want her to cooperate, or she has nothing to give.
But on that, so point one and point three, which is she's made her choice, she's got nothing to give. But on point two, explain to me the rationale behind the Southern District in New York. Is there a scenario where they wouldn't want to go after a more prominent or more powerful person? Because that's the theory on the street, so to speak, right?
Well, in the sense of, does one of these more powerful people, and we're really talking about political people, does one of these more powerful people on the Democratic side or on the Republican side have influence over the Southern District of New York? And I say, no, they don't. Okay. And on the more perhaps valuable is the thought of, can Ghislaine Maxwell actually put one of these more powerful people, an either political party, literally in the room as that she was a witness to what happened? And the answer to that might be no.
Got it. So ultimately, the Southern District would be reluctant to go after any prominent politician, and we've seen a lot of names thrown out there, unless they thought they had, so to speak, in an open shut case that they were able to.
I think that's right. But there's also another factor here that I think we have to consider, which is this substitute for Jeffrey Epstein figure. Jeffrey Epstein was public enemy number one. He was the most notorious. He was someone whose activities, once they became publicized after Julie Brown's work in the Miami Herald at the end of 2018, that the stories that started to emerge about Epstein were so repulsive. They just turned your stomach. And once Jeffrey Epstein is found dead in his cell in August of 2019, then didn't the government have some real need to have someone pay for these crimes? And it's Ghislaine. And would the country just go out of its collective mind, and perhaps rightfully so, that they would go out of its collective mind, or that we would go out of our collective minds, is if she got some kind of a pass, as well as Epstein not being alive, that no one paid for the ultimate abuse, who was really a serial abuser, a trafficker. She's being charged as a trafficker. Like, do you give up the trafficker in order to get one prominent politician? It's a big political calculus.
And it is that either or. You can't do both, is what you're saying, or you don't believe you can do both without her cooperation.
I don't see how you give Galen a pass in order to name a prominent politician. And maybe you don't. Maybe you, the government, say, well, look, you're going to have to do 5 years or 10 years. You know, you'll still have a life after that. We just can't give you immunity, and we can't let you plead to probation, but we need this person's name. I don't know how people would feel about that unless, as to use your phrase, the case was airtight. And, you know, we really don't know if these political names that have been tossed out there, if it has any reality about them. We really don't know.
How much pressure do these prosecutors feel right now, given the sentiment in the country that Jeffrey's dead, he can't serve his time in prison as most of us believe he should, and so they're going after her? How much pressure and to what extent does public sentiment, how much is that taken into account when these prosecution decisions are being made? But what is it like to be them right now?
Well, let me answer it in your last question. What is it like to be them right now? You're concerned because this is a big case. This means a lot to you. You need to win this case. And by the way, you don't need to win every count. You need to win, you'd like to win 6 counts. But if you win 1 count, isn't 1 count giving you a victory? As long as you can win part of this case and she goes to prison for some significant period of time, then you have won. In terms of public sentiment, I'd like to think that prosecutors are not influenced by it, but we're all human beings, for heaven's sake. So, of course, we're aware that the public sentiment about Jeffrey Epstein and Ghislaine Maxwell runs quite deep.
One of the things that's come up is, as people are like, well, you know, they're going to let her off because these prominent, powerful entities are controlling, and you've made clear that, you know, that they don't impact the Southern District's decisions, is media coverage of this. You've been covering these trials for a number of years. Where do you rank media coverage and attention to the Ghislaine Maxwell trial versus other prominent trials of the past couple decades?
I'm actually surprised how little media coverage there is. I know if you read certain media outlets, you will get a lot of coverage of it. If you read certain news outlets in Britain, you will get a lot of coverage. If you read the New York Post, you will get a lot of coverage. If you watch CBS News, I think you get some coverage. I think, you know, we have tried, because we've covered this case from the beginning, that we like to keep our thumb on this case. But I don't think it certainly has not demanded the coverage. For example, when I went to CBS this time in 2013, my first assignment was the summer of 13 to cover the Whitey Bulger case up in Boston. And he was a notorious gangster. And he was responsible for many a murder and head of the Irish mob in Boston. And eventually, after some months of trial, was convicted. We covered that case on CBS News. It seems to me, I don't know if I'm precisely correct. Out of a 5-day week, we definitely covered it twice a week, most times 3 times a week. And there were certain times we covered it 5 times a week. I was up there all the time. We had a reporter up there all the time, like Ghislaine Maxwell. It was a federal case, no camera in court. We were the eyes and ears. I don't see that happening, at least not in mainstream media, and frankly, not in cable. And I'm surprised at that. Now, we know there's, as I would say, a cajillion reporters who are there, but I don't see it every day. I will see it in the British papers much more regularly than I see it here.
Yeah, I've been following, like, the New York Times has a blog all day long, the Reuters has a blog. I mean, there's a number of the key outlets, the AP, prominent national outlets, the Wall Street Journal, are covering it. But I think it has been notable that
But
television,
in a different way, as you
in a
put
different
it.
way.
It's on a blog, it's on Twitter.
Yeah.
There are ways to cover it every day, where, I'm not in the courtroom every day, certainly, or in the overflow room. So I make sure I read the transcripts, I read our detailed coverage every night, and that I also stay during the day following it on a blog or on Twitter. But even from this podcast, you have to have viewers who want to follow something. It's not put in their face. They have to go find it. And that's
right.
very.
And the distinction I would say is the television coverage, right? The television coverage has not been up there with other trials. And I wonder how much of a factor you think cameras in the courtroom play. And I'd love to get your take. I didn't realize the history of cameras in federal court going back, nearly 100 years now, to the Lindbergh kidnapping case, that there was media coverage of that, and partially out of the fallout of that, and please correct me if I'm wrong, there was a decision at the federal level to ban audio recordings and video recordings from the courtroom. What do you make of that in 2021? Do you still feel that's relevant? Do you feel it's important for folks to know? And what impact do you think cameras do have in the courtroom?
Well, I've often said, because my leaving the law career as a primary career and going into television was to go to be an anchor at Court TV, that I was hired specifically to be able to cover the O.J. Simpson case. And when I used to talk, and I went all around the country talking about cameras in court and why I felt they were so important, and I still do, is that I used to joke that the camera paid my rent. Well, now the camera does not pay my rent. I talk about all kinds of legal issues that may not in any way be televised. So I can say my conclusion, perhaps far more unbiased than when the camera did pay my rent. I believe in cameras in the courtroom. We know from the Supreme Court opinion, where Justice Brandeis, in a completely different context, talked about sunshine being the best of disinfectants, that what we want is transparency. And transparency in court means that, just as in the old days, people used to come to the public square and go to the courthouse and sit in the gallery. And that's how they knew what was happening in terms of the world of justice in their community. So I have strong feelings that cases should be televised, whether it's at the state level or the federal level. Now, where does it get abused? Not only, of course, as we go all the way back to the Lindbergh case, but where we see it get abused is when a judge becomes enamored of a camera in court. And some of the worst offenses, of course, we saw during the O.J. Simpson case.
Lance Ito.
Lance Ito, who just was truly enamored of that camera. And he literally would have arguments, lawyer arguments, that were done in chambers. And then he'd bring people out to the courtroom, and he'd let them, it was already on the record, but he'd let them repeat it on the record for the sake of the camera. Well, that could have been a good thing. But then what we saw on the other side was the horrible overplaying to the camera, and celebrities would come to watch the Simpson case, and he would take a break and bring them back into his chambers to have a conversation with them. It was really not the best of times for cameras in court. And we were very concerned at Court TV at the time that it might really hurt the reputation of Court TV. Most judges are pretty good about cameras, that they don't make anything change. I was a lawyer in courthouses in Massachusetts when cameras came into the courts in 1981. And the great thing about the camera was it was stationary, it was small, it was in the back. And so I think the only thing they ever showed of me was the back of my head, because it was focused on the witness. Or perhaps they showed me in profile when I was giving an opening statement or closing argument. It was not a movable camera. It was not a camera that was making celebrities of lawyers. And that really is how it should be. You should have the dignity of the court. I was on a committee that was on an advisory committee to the United States Supreme Court, having to do with law and the media. That was what it was called. And there were a group of federal judges on that committee, and there were a few of us who had been named in various roles to help that committee make decisions on all kinds of things involving the criminal rules of procedure. But one of the constant areas of battle in that committee had to do with cameras in court. And in fact, that was where I met Steve Brill, who founded Court TV, because he came to try to persuade the Rules Committee to allow cameras in the federal courthouses. There was a time where there were cameras in federal courthouses in civil cases. And when I was at Court TV, we had a few of those civil cases on Court TV, and they were extraordinarily educational. And they really were helpful, I think, to the American public to understand what happens in a civil suit as well as a criminal case. So it's a long, winding answer to say, I do believe cameras should be in court, and they should be in every trial that involves the public interest.
And so then I'll ask you to make a prediction. Is there a scenario, given the arguments that you've heard so far, where, I don't know, in the next decade, we could see cameras in the court? And by the way, I'll take that all the way up to the Supreme Court, though they like to do their own thing over there.
Well, the Supreme Court has always felt very strongly, at least publicly, what has been said is it had to do with their security, that they did not want to be photographed during arguments. In fact, it's quite remarkable that we've gotten audio out of the Supreme Court, and I think that's all we're going to get. I would like to think that the federal courts would at some point allow cameras, but frankly, I don't see it. And the reason I don't see it is because the more that the media becomes sensationalized, I don't know how it can get any more sensationalized than it has as the result of a 24-hour news cycle, and that also then includes social media. I think that the judges would probably run from the cameras rather than run to them.
I know you have to go, but I want to just get to the Michigan situation real briefly to get your quick thoughts on it.
Sure, of course.
So we had the parents of the school shooter in court today. They've hired their own attorney, incidentally, the attorney who defended Larry Nassar, to defend them. Ethan Crumley, the 15-year-old who's being tried as an adult as a school shooter, has a court-appointed attorney. The latest that we're hearing is that the attorneys are not coordinating in any way, shape, or form. What do you make of that whole situation? And is there a rationale, without knowing the family dynamic there, for why their son is being left to a court-appointed attorney, whereas the parents have a hired attorney?
I can't give you an answer about why the child who is being treated as an adult, has a court-appointed attorney, but yet they seem to be able to afford their own attorneys. That seems to me rather peculiar, and I'll leave it at that. But when it comes time for why they are not cooperating, that is the lawyers, and that they are doing each case on their own, there's good legal strategic reasons for that, tactical reasons for that. The 15-year-old is the shooter. There is no debating that he is the shooter. And so he is stuck in what happened that is well documented. And when I say stuck, the real question is there really some kind of mental illness defense here? And if not, then what is going to happen to him? There can be no doubt that he will be found guilty, and then the question will become his punishment. But the parents are in a very different situation. The parents are charged with involuntary manslaughter as contributors to the deaths and the injuries during this horrendous and tragic school shooting. Their defense is that they had no idea what their son was going to do. And their defense may be, as we listen to snippets from their lawyers, that they had locked up or secured the weapon, and that they did not make it easy for the child to be able to get that weapon and go to school, and that they did not see signs of any kind of mental illness or deterioration on the part of their son. So the defenses are inherently antagonistic under the law. So it makes sense that, number one, the lawyers should not be the same ones, that they should not be on the same track, and that they should actually, the parents should be tried separately from the 15-year-old. So I get that legally, strategically, tactically. There is no joint defense agreement. There is no cooperation happening from the 15-year-old to his parents or vice versa. But the thing of hiring a lawyer, I don't know what the lawyer costs for the parents or the lawyer's cost for the parents, and letting the son have a public defender, that I think makes me a little queasy. That's not
Rikki,
illegal.
well, I could go on for several hours and take up many hours that you don't have available to keep going, but I'm incredibly grateful for you taking a moment to bring your wisdom to all of these cases. And as we continue to watch the Maxwell trial, we'll continue to look for your insight on CBS. And I know that your Twitter feed as well, I'm a fan of.
Well, thank you for that. And also thank you to the people who follow your podcast, because their questions have been extraordinarily perceptive. And I apologize that in the length of time, we could barely scratch the surface of the intelligent questions that they have put forth.
Well, we'll find a time, God willing, in 2022 to continue the conversation, Rikki. But thank you so much, and have a wonderful holiday season.
And the same to you. Thank you for having me.